evening. You've joined us right here in the India Development Debate. I'm Taneia Bhardwaj coming to you live from our Mumbai studios. Well, no easy way out for errant promoters. In a big endorsement of the Modi government's Insolvency and Banking Code, the Supreme Court today ruled that all is well with the new legislation to deal with willful defaulters. Quashing petitions filed against the IBC, which alleged that the new law is discriminatory. The country's top court ruled that the ban on defaulting promoters making a backdoor entry through the bidding process is very much valid. The government is clearly a happy lot. You had Rajiv Kumar, Secretary of Financial Services, saying that the ruling will lead to a robust credit culture. The Supreme Court verdict comes as a big blow, though, to the rulers of the SR Group, who've been looking to regain control of SR Steel by offering to clear all dues off the company. The Supreme Court's thumbs up to the IBC and what it really means to companies and lenders is what we're going to be discussing this evening on the India Development Debate. And for that discussion, we've got a special panel joining in. Let me introduce you to them. Shardul Shroff, Executive Chairman at Shardul Amarchand Mangaldas. We've got Behram Vakil, co-founder of AZBN Partners, founder FinSec Law Advisors. Sandeep Parekh is here with us, and our consulting editor, Maithili Bhusnurmat, joins in as well. Good evening to each one of you, and thank you so much for sparing the time. Mr. Behram Vakil, I'm going to begin by asking you, with the IBC code passing the constitutional muster, would you say it now paves the way for speedier resolution of insolvent companies?
Yes, thanks a lot. I think I would definitely say that. I think it's really a landmark judgment delivered in a super expeditious manner. I think we should all be very appreciative of that, and that has been one of the hallmarks of this entire process, how fast it has moved, not only by Indian standards but by global standards. And really that's because it has been such a collaborative effort. You know, the list is too long, but all the Supreme Courts, NCLTs, NCLATs, the ministries are fantastically hardworking and dynamic regulator. And last but certainly not least, the RBI that kind of kicked it off with the first 12 and then consolidated in a very strong way with the Feb 12 circular. So I think this certainly paves the way. It shows that the country is clearly on a new track, and as was said and has been oft quoted already, that it puts the economy in its rightful position. So I am delighted and extremely optimistic.
Mr. Shardul Shroff, opening comments from you as well. Will the Supreme Court ruling, like the government claims, help usher in a robust credit culture?
Yeah, so firstly, I would entirely agree with Behram in relation to his comments on the entire framework, and the regulators and people who are supporting the system has clearly done a lot of nitty-gritty work to enable this law to be robustly applied. This is a landmark judgment. It's a path-breaking judgment, because all the kind of frivolous claims which used to repeatedly come up will be put an end to. There are some issues which still need to be resolved, especially in relation to the question of inter se rights within the two classes of unsecured financial creditors and secured financial creditors. But that's something which will come in due course to really enable this law to progress in a very dynamic and helpful manner. It is clearly one of the landmark economic legislations of our country.
Mr. Sandeep Parekh, let me ask you, one of the other things that sort of jumps out in this judgment, and, it's a 150-page long document, is how it talks about the need for economic legislation to be allowed to take its own course. And just to quote from the judgment, it says judicial hands-off qua-economic legislation. How crucial do you see this, given that IBC, from the very beginning is a legislation that's been mired in litigation?
Yes. So, I think it's very important to recognize that courts have been traditionally been very hesitant to interfere in economic legislation, simply because it's complex and they're not best equipped to second guess what regulators and governments do in these cases. And from 1969, there's a famous RBI case onwards till now, as we saw today. There's clearly an emphasis saying of hands off, that the government is there. They've used experts like one of the panelists here, Behram Vakil. So I mean, these people are best equipped, and we are not going to second guess this. And I think the entire judgment can be summarized in one line which they used towards the end, that the defaulter's paradise is lost. And I think that sums up the ruling quite well.
It's a great segue, Maithili, for my question to you. For far too long, we've seen promoters treat debt as an equity. With this judgment, and to quote what Sandeep just said, and the judgment itself, has the defaulter's paradise been lost and the economy's rightful position been regained?
Well, I think that's a little too sweeping a judgment from Sandeep, and I know the Supreme Court has also perhaps said that. But the fact is that they must understand why has a default occurred. One needs to look beyond and not condemn all defaulters, tar them with the same brush. So I think one needs to have a very distinct treatment for a willful defaulter as against an account or a borrower where the account has gone into default for circumstances entirely beyond his control, as in the case of the cancelling of the coal auctions, the telecom spectrum auctions. So similarly, there could be many instances where entirely because of circumstances beyond the promoter's control, the account has become a non-performing asset. So I think it would not be correct to say defaulters paradise, because remember, not everybody wants to default. So I think it's important to make that distinction. And while it is good that the Supreme Court has said that it's hands-off economic legislation, I do wish the Supreme Court carries this forward in the case of all economic legislation, which has not happened in the past, and I doubt if it's going to happen in the future also, as we saw in the case where the court said, yes, auction of natural resources is the best way of going about it. So yes, the Supreme Court judgment has clarified a number of clauses in the law, but I'll come to the infirmities in the law itself, Taneia, and I think I'm going to be a minority in this, but I'm going to come to it a little later, because there are some minor infirmities in the law itself as it is framed, particularly section 29A, which go against the interests of the larger macroeconomy.
Okay, Maithili, we'll revisit that. But Behram Vakil, let's talk about, some of the important decisions today. Operational creditors will not be treated at parity with financial creditors. This strengthens the hands of banks further?
No question. It definitely does. And I think it's a very important clarification, because these waters had been muddied quite a bit by some earlier judgments. And I just want to put it out there that, in fact, one of the goals was to strengthen the hands of the operational creditors. And the data shows that to date, the recovery of the operational creditors has been marginally higher than the financial creditors. It's very close, about 0.5 difference. Recovery rates are just under 50%, but operational creditors have got more than financial creditors. And this is only through the IBC process. As you can well imagine, no promoter is going to risk his company for smaller amounts. So a lot of in the lakhs and in the early crores, I'm sure people have paid off and settled rather than risk an IBC proceeding. So I think this has been a very strong suit for the operational creditors. And I also would like to compliment you. I think you hit the nail on the head that one of the key, there are many important aspects of this judgment, but one of the key aspects is that they said for economic law, it should be virtually hands-off unless prima facie there's something really inequitable, and similarly inherent powers of the tribunal. Similarly, I think para 85 said that you should experiment and continue with the success. So there's really lots to be smiling about in this judgment.
Shardul Shroff, I'm going to keep it with, the operational creditors for just a little bit more. How big a jolt is it for operational creditors of bankrupt companies, especially because, you could say that they saw a little bit of hope after the court last month, I think it was in mid-December sometime, suggested that they be given a voice, including voting rights, in the resolution proceedings in proportion to their debt?
I think the judgment analyzes the discussion in the banking committee, which was a precursor of this law, and clearly records that this issue was discussed at that committee and that it was decided that it should be sent finally to the standing committee, and observations of the standing committee are also relied upon by the judgment, which shows that the legislature as also the committee really rejected the principle that the operational creditors have the same say as financial creditors. It was pointed out, and it is there in the judgment, that up to 10% of the operational creditors are allowed a right of audience in the committee of creditors, though they don't have a right of vote. So the judgment has really put it in complete perspective that the right of being at par with the financial creditors is not there. It is not the basis of making of this law, and it continues that without really disturbing it. So to the extent that they were seeking a right to be heard and a right to decide and vote, yes, it's a clear negative response or a negative principle rejecting that policy.
Sandeep Parekh, now many observers are wondering how today's Supreme Court verdict is going to impact the ruyas of the SR Group, who've been, looking to regain control of SR Steel by offering to clear all dues of the company. What's your understanding of that?
So, I won't speak of this particular case. I think, generally speaking, I think what has happened is earlier defaulters could game the system, and which is where kind of the moral judgment comes in, which Maithili spoke of, that defaulters got away for 10, 15, 20 years, playing games in litigation. And of course, lawyers were beneficiaries of that, but not in a good way. So I think the whole episode of creative destruction was never allowed to happen in the Indian economy. So we had so much of deadwood in the economic system. The regeneration therefore kind of stopped. You had all this undergrowth not allowing the trees to grow. And secondly, I think broadly I agree with Maithili that we should not be passing moral judgment with this genuine failure. But at the same time, in the majority of these lending situations where promoter holding is 50%, the promoters almost always give personal guarantees. So they put their neck on the line, and then I think it's fair game for the creditors to go after the personal assets of the guarantors or the promoters. So I think that we should not be passing moral judgments on genuine defaults. I agree, but I think IBC is agnostic to that. If there's a default, then whatever the legal obligations and legal rights of the creditors, I think that they should be enforced as per those contracts.
Maithili, come in on that. There's a school of thought that believes that IBC denies a level playing field for promoters whose businesses may have turned unviable due to external factors. Do you think it's completely unfair to shut the door on them forever?
I would think so, certainly, Sanya. And I think the standing example is that look at what's happening in the US with the Sears, the retail giant, which was very popular. In fact, it was the most popular retail giant in the US in the 60s and the 70s. Yes. Today, the company is going into liquidation. And the former CEO and the former chairman of the company, a hedge fund of his, is being allowed to take it over at a much discounted value. So I think to tar all promoters with the same brush, I think is very unfortunate. And Section 29A specifically rules out a number of categories, which includes anybody or any company whose account has become non-performing for more than 1 year, anybody who might have given a guarantee, anybody who is disqualified to be the director of a company. Now, you could be disqualified for being the director of a company if a check bounces. Now, these are very stringent conditions, and in the process what is going to happen is that you are not going to get the best value for what is going into liquidation or bankruptcy. So clearly the Supreme Court, choosing between maximization of value, which is what is more critical, has rather gone by the due process of law. So they've looked at it from a very legalistic view. So yes, it is important to punish somebody who is willfully defaulted, somebody who is defrauded, but there are different laws under which you can proceed against somebody who is a fraudster. In this process of ruling out a number of categories, 10 categories under Section 29A, 29A. So here, of course, as I said, there's an infirmity in the law. The Supreme Court is not to be held responsible for this, but this is something where the government has clearly, gone beyond what is necessary, and in the process, we are going to get much lower value than what we could have had we allowed a wider class of people to bid, a wider section of companies to bid. And one very short point about operating creditors. Yes, it is true that you need to put them as differently from secured creditors and financial creditors, but we had the same Supreme Court and the government put home buyers as part of the committee of creditors. So I think there are these contradictions and these conflicts, and I think that does not send a very good sign. If you're going to keep the operating creditors out, then why have you brought the home buyers into the committee of creditors? So I think with that, I rest my case.
Right. Okay. Behram Vakil, I'm going to go back to SR Steel and the Ruiyas. And in this case, what is your understanding of how Section 12A will apply? Will the applicability, you think, reach the Supreme Court? And, in terms of today's judgment, does it sort of give a clear definition of, various sections under 12A?
Thanks. If I may, I'm just going to very quickly go back to the arguments that were just propounded.
Sure.
So, on 29A, the moral hazard issue, etc., is already a lot has been spoken, and it's certainly a strong view that India has taken as a country. All I can say is that if you look at the macro and the objective, none of us are going to say there isn't an NPA problem. So very broadly, you all know the figures much better, but say I take 10 lakhs to make it easy, 10 lakh crores, about 25% of that has been recovered in this short time frame. That is mind-boggling, forget by Indian standards, even by global standards. If you talk to the US, Europeans, Chinese, anywhere, to recover this amount of money with a new law in this time frame is amazing. And I think that one of the big reasons for that has been Section 29A, because more than half of this 2.5 lakh crores that has been recovered by the banks is because of the threat of IBC. Again, no promoter, it's human nature, is going to want to lose his company. So they are coming to the banks earlier, which is a very good thing for the asset, because there's a direct correlation between recovery and time taken. And therefore, they are coming quickly to the table, they are making sensible negotiation, and these pre-NCLT closures will happen more and more. And you need that, otherwise the system will get clogged up and you'll have infrastructure issues. So I just wanted to bring that up, because I think we need to look at the data also when we make all these arguments. Coming back to 12A, I think, it's one of the issues which is still needs some clarity. That's my personal view, and as you said, I think that will be forthcoming in the SR case. It's been clarified in this judgment that it's constitutional, valid, no issue there whatsoever. But at what point can you come in? Yeah. And I think it's a very dangerous argument, this maximization of value versus process, because the ideal analogy, can you come and score a goal after the match is over? Then will anyone come to play with you? Can you score a 6 after the 20th over? So if you want to have, and we are right in the beginning, I mean, we've got thousands of cases to go. So if there is no robustness in the process, if there is no sanctity to the process, players won't come. So I think there definitely needs to be a sanctity to the process. Sure. And within that process, of course, maximize value.
Okay. I have time for one last question. Mr. Shardul Shroff, I'm going to talk to you just looking ahead. You know, the genesis of this judgment is the Allahabad High Court ruling in April, which sort of declined to give private power companies any interim relief on that 12 February RBI circular. With today's judgment, do you expect the Feb 12 circular to pass the muster?
Yes, I believe it will pass the muster. In fact, I wanted to mention that, and I also wanted to mention a little bit of the SR angle. So, if I may, let me explain the impact. I think clearly the judgment says Section 29A subclause J is interpreted in the context of relative and related parties. An argument was raised in the SR case that Mr. L.L. Mittal is disqualified on account of his two brothers, P.K. Mittal and Vinod Mittal, who are relatives under the law, have NPAs and have not really cured them. So this judgment clearly says that if they are not directly connected with the business, it is not a disqualification. Secondly, it also reinforces the ArcelorMittal previous judgment, where it was found that Mr. Ellen Mittal had two other companies, namely Uttam Galva and KSS Petron, where he was asked to pay by the Supreme Court. So this clearly enunciates the doctrine that if you have any companies which you are the promoter of and for which you have not retired or not standardized the NPA within 1 year, then you are not eligible. That principle will still apply under the Section 12A proceeding, because the Supreme Court in the ArcelorMittal case gave 8 weeks to the Ruya group to pay up all their NPAs in relation to every company where they are in a promoter situation. So in my view, the decision now at the NCLT does not depend on giving the full value of the arrears or the dues in the case of Essar Steel. They have still not cured their NPA problems with reference to other Essar companies, and therefore their disability or disentitlement continues. Two issues, or three, the third issue, as I said, one is the relative argument falls by the way. The second is that can a settlement be done after the process has been heard right up to the Supreme Court and time was given to them to clear up all their arrears in companies where there were promoters? And thirdly, can a right of redemption really be exercised contrary to the provisions of Section 29A just by offering payments in relation to one specific company and not in relation to the others? Having seen in the judgment of ArcelorMittal that Mr. Mittal was directed to pay the arrears of KSS Petron and the Uttam Galva, how is it fair to say that I can pay up the full value of Essar Steel and not retire the other companies' debts where I am an NPA holder or an NPA promoter? So all these principles effectively come out very clearly by this judgment, and in my view it simplifies the process in relation to Essar Steel at the NCLT Gujarat. This is, I think, the benefit of this particular judgment, and I think it'll quicken the resolution in Ahmedabad.
All right. Thank you so much. Unfortunately, we're completely out of time on this discussion, but I want to thank each one of you, Mr. Shadul Shroff, Behram Vakil, Maithili Biswanath, and Sandeep Parekh. Thank you so much.